My name is Nima Shirali. We're here today with Mr. Jay Chauhan from Jay Chauhan's Law Office in Richmond Hill, Ontario. Mr. Chauhan served for 24 years as a deputy judge at the Superior Court of Justice in Ontario. It's a privilege to be here with him today. We're going to be talking today about the topic of drafting a claim. It's going to be a topic that we will have in our CPD lectures this month, July 2017. We're just going to have a brief overview as to what the seminar will contain. And I'm going to ask some questions with regard to this topic to Mr. Chauhan. The first question, Mr. Chauhan, is with the very first stage of interviewing the client, would you say a few words with regard to what that entails?
The first interview is extremely important with the client because in that interview, you're establishing a relationship with the client and telling the client in the legal terms his cause of action and then how that cause of action is going to be translated into drafting of a claim.
I see. And after interviewing the client, would it be advisable to speak about the retainer agreement and to have that signed at that stage?
It would be extremely important. One of the things that goes wrong very often in the lawyer and client relationship is the question of what is it that the lawyer is going to do and what is it that he's going to do for what amount of money. So this understanding or misunderstanding can arise because of the expectations of the client and how much can the expectations of the client can be delivered by the lawyer and for what value. We have, if I can use the expression, a private enterprise legal system, but not the medical system where the government pays for everything. And therefore, when you talk to the lawyer, then there is a question of paying him for asserting your legal rights in the legal system, except for the legal aid that you get. And therefore, what does he do and how much does he get paid is defined often in writing and also in a deposit that you would give to the lawyer called retainer. Both are called retainers, but that retainer is very important to draft and deal with the lawyer when you first meet with the client.
I see. And is there a particular approach that you may recommend with regard to finding the actual legal issues and the causes of action?
Well, I have a couple of comments actually. When you draft a claim in the common law that we follow in Ontario, but not Quebec, but the rest of Canada, in England and other common law jurisdictions, including US, India, many of the West Indian islands, we have a common law system where we have historically developed causes of action, as they're called in the law, which means the reason why you want to bring an action. So when you commence an action, it is extremely important that you identify in the first meeting and in your drafting what is called the cause of action. To give you an example, it is a contract. If it's a contract that two persons agreed with each other to do certain service or provide some goods for a certain value, then you have to define what those values are and then how much you're going to be paid and how long the contract will take to complete. And then there are legal words to describe all the events in the law if the court is deciding on the issue, such as the consideration, damages, consensus, etc., which we will be discussing in the seminars that we will be doing. But these are the issues that you need to identify when you're drafting the claim.
I see. And having worked with you here on different files, I've had the chance to contribute to the actual drafting of claims, and I've noticed that we go through several drafts before the claim is actually sent out. Is there, with the actual stage of drafting, is there any kind of advice that you may give to legal professionals to help them become more efficient?
Yes, I think, I mean, you worked with me anyway for almost a year now, actually. You were also a high school student when you first came here years
Yes.
ago. So you'll recall, actually, that the way we do the thing, and I think in my view, if I can explain to the audience on this video, that when we do a claim, if you can want a comparison of medicine with law, the precision of the language that you should do with research should be that in the words, if you can reach the point of a surgeon who cuts through the situation to describe in accurate words what your cause is the skill that you want to develop actually. And in the case of law, my experience after 40 years plus of practicing in the law, it is my view that this precision does not get achieved because you study them in the school. So what we'll be dealing with in explaining this in the seminar will be how do you, on an ongoing basis, do the research, perfect your thinking, and then use that thinking and improve the thinking. And as you pointed out, Nima, that you would redraft the claim because you're still thinking. And I did a lecture at Osgoode Hall, we were there, and to the students as to the future of artificial intelligence, would we at one point be able to tell the computer to say that we have a claim and draft it? I think it's a long time from now. It's a human function, in my view, to evaluate things like negligence. How much wrong did you do, and would you define this as negligence? Is an evaluation process that you have to learn.
I see. And with regard to filing and serving, I've also noticed that the way that we do it, it is a particular way. For example, the way that we compose the cover letter to be sent to the court is something that we have spoken about. Is there a word or two that you can say with regard to the filing and serving stage of the claim?
The filing and serving are definitely a very important next step after you draft the claim. There's a special form in the Small Claims Court which we'll show you in the seminar, and they've been created to simplify the procedure of drafting plaintiff, defendant, and the story, so to speak, and then the service. The service rules have relaxed over the years, and in the seminar when we do it, we'll be describing the rules of service properly. When you prepare it and you give it to the defendants that you've defined in the claim, there is a special method by which you have to give these documents to the defendant. So those service rules are very important to learn.
Right. And in terms of researching the drafting of the claim, from the perspective of a judge, since you sat as a judge for 24 years, what does a judge like to see in terms of research for a claim to have been drafted?
Well, there is some difference between the lawyers and paralegals. I think my experience with as a judge watching the paralegals and lawyers in the courtroom is that the paralegals need to give more attention to the research, because in their training there is not enough amount of the theoretical law for which the lawyers are given 3 years to learn the substantive law. So I suggest to the paralegals that they do more research, but this does not mean that the lawyer should not do it. In my view, more accurate you are, more often you look at the sections and research to be sure, better will be your case, and you will be better off than the opponent in trying to win it.
Excellent. Thank you very much. I really I'm looking forward to the program. If you can just say where and how the program will be conducted.
These programs, we are going to be doing regular series with one of the members. Barman has got a premises in near Eglinton and Warden, and it's a mall called the OneCenter.ca, and these programs will be announced on our Facebook at Angel Mentorship Group. We'll send out emails. If you have any friends that you want to bring, you're welcome. And if you look up the OneCenter.ca, there will also be the listing of what we'll be doing, and we'll be mailing out to you also the programs when they're prepared and the dates, and we'll be asking for the Law Society to approve of our programs before we present them.
Excellent. Mr. Chauhan, thank you very much for your time, and I look forward to the program.
Thank you.